Rich, why do you think that she's giving him so much latitude here? I mean, there could have been so simple. The minute he outbursts, Mr. Brooks, that's it, you're going to the courtroom. She's giving him so much leeway, and I feel is just incredibly respectful to what he's doing here, even though it is incredibly inappropriate at times where he's just interrupting the judge with baseless accusations.
The judge is protecting the record. The judge thinks this, I mean, I think the judge thinks this guy is heading to a guilty verdict. And so she wants a record that he's being given every opportunity to make his legal points, even though he's representing himself, that he's being given every opportunity to stay in the courtroom, even though he's acting outrageous, that he's being given every opportunity to mount a defense. And she wants that record to be very clear, so when, at the end of this process, he is convicted by the jury, which is, I mean, I'm pretty sure what's going to happen here, that is safe on appeal, that he doesn't have some issue he can raise to undo it all. This guy was told extensively at the beginning of this trial what the adverse consequences are of representing yourself. I watched that. The judge was extremely patient, went through it line by line with him. She was explaining Latin terms to him. She was telling him it was a bad idea. And all the stuff he's complaining about now, he doesn't have access to law books, he doesn't have the same kind of access to the files. The judge told him that was going to happen. So he knowingly and voluntarily took on defending himself. And I don't know if he's second guessing that now or if this is just a strategy, which it may be, to try to find another out here. Now he's going to say his rights are being violated because he was allowed to do the thing that he demanded to do. This judge has been extremely patient with him. I would make the argument she's been too patient with him. And I've run out of patience with him.
Well, putting aside all these issues that he believes why the case should be dismissed, when he is cross-examining witnesses, and by the way, he hasn't presented an opening statement as of yet. He probably will, maybe he should, and we believe that he's going to call numerous witnesses. What has been his defense? Have you seen a cohesive defense? Is it an issue of identity, who was driving the car? Is it an issue of what were the actions of the driver? What do you think his defense is?
Well, here you get to a central problem of representing yourself. He doesn't understand legal terms. He doesn't understand procedure. He doesn't know how to do things. I don't know what his defense is. I really don't. I mean, he has suggested at times that maybe it wasn't him in the car, but that seems an absurd defense. I mean, that seems to be pretty well established. I haven't heard him say, you know, it wasn't on purpose, my foot got stuck on the gas. I mean, I could imagine.
He has said the horn, right? Perhaps there was a horn being blasted by the driver to alert people that he was coming through?
Yeah, that's not, I mean, yeah, that doesn't give you the right to run over 6 people. I mean, that's a ridiculous defense. I don't know what his defense is. He has indicated he may testify, right? So presumably we will find out then, if he does that, what he says happened.
And he would just go on a whole, you know, story, lay it out, and then of course he'd be subject to cross-examination, which, oh my goodness, what that would look like. Thing, Rich, and this is what strikes me. I'm going to give him the benefit of the doubt. It seems to me that he legitimately believes what he's saying. It doesn't, I will say, let's say it's not a delay tactic. It seems to me he legitimately believes what he's saying about the law or his legal interpretation of this. And when he keeps saying, Your Honor, I think the jury has a right to know why I can't ask these questions in front of the jury. He says, why, you know, when he's objected and he goes, grounds, why are you objecting? He's like, I think it's important for the jury to know why you're not allowing me to answer these types of questions. So if he's convicted, I think there's a part of him that could be shocked and not understand it. Or if he makes an appeal and he argues what he's arguing, it won't be successful, he'll be shocked there. I think he legitimately believes what he is saying.
I'm going to react to that this way.
Okay.
I don't care if he legitimately believes it. I don't care. I said before, I'm losing patience with this guy. Yeah. He should have a lawyer because he doesn't know the law. He didn't go to law school for 3 years. He hasn't spent his life litigating cases. I get it. He's in jail. He's on the internet. He's reading a bunch of things. He's finding out about sovereign citizens. He's finding out about the 6th Amendment. He has Google. Congratulations. He's not a lawyer. He's not competent to be a lawyer. He doesn't understand the law. He doesn't understand the procedure. Or he does understand, and he's simply trying to manipulate the court.
That's what the prosecution believes. Rich, I need your help. Where's he going with this?
Put all the nonsense aside, focus on the substance. The two defense theories he's suggesting are: one, it wasn't really me in the SUV, and two, it was a mechanical problem, the SUV was out of control. Aren't those two defenses contradictory? If he wasn't in the car, how does he know it was a mechanical problem? So he's not picking a consistent theory. He's throwing everything he can out. He's got a bag of objections. He just reaches in and throws them out at random. Hearsay, relevance. And he doesn't have a solid defense.
All right. Well, I'll be curious to see what an opening statement would sound like.